And throughout the trial, we're going to follow this. But now we thought, let's do something a little bit different. Let's do a preview of this, try to see what it will look like for each side. So we have with us right now two talented attorneys who are going to play the roles of the prosecution and the defense, giving us kind of condensed versions of how they see the opening statements and arguments going to be in this trial. My friends, I'm joined right now by two of my favorites. The role of the prosecution will be with Bernardo Villalona, who served as a prosecutor in the Homicide Bureau of the Brooklyn DA's office. And for the defense, Bob Bianchi, criminal defense attorney, former New Jersey prosecutor. Great to have you both. Okay, so Bernardo, I'm going to start with you, the prosecuting attorney. We have this cute little clock we're going to put up that says 30 seconds for your opening statement. You go.
Judge, jury, executioner. On May 1st of 2023, Daniel Penny played judge, jury, and executioner when he placed his arms around the necks of unarmed Jordan Neely, applying pressure for over 6 minutes to a man that was unarmed and was not posing an imminent threat to him or to anyone else on the train, as people pleaded for him to stop.
There you go.
He didn't.
All right, Bernardo, great. Okay, Bob, go to you. 30 seconds, opening statement.
Wow, here's a man who's been arrested 40 times, got a mental health condition, was under K2, which is a synthetic marijuana, which creates violence. Many of the passengers are going to get up there and talk about how they were in fear of their life. They've never dealt with anything like this. He was aggressive. He was threatening to kill people. And the defendant stood up. And who should be in the defendant's chair isn't the victim or the defendant. It should be for the state, because they didn't provide mental health. They had to get 1,000 National Guard to clean that subway up. It was a cocktail that was ready to happen from the beginning, that both the defendant and the victim are the victims of the state of New York's failure to do their job.
Okay, so playing the role of judge, I'm now going to hit follow-up questions for you both. Bernardo, I'll start with you. Several witnesses say they felt threatened. You know, this is from the defense filing. One witness saying, I've been riding the subway for many years. I've encountered many things, but nothing that put me in fear into me like that. Another quote, believed he was going to die as Neely was approaching him. You have another one, recounted Neely saying, I want to hurt people. I want to go to Rikers. I want to go to prison. I mean, these are people that have legitimate fears. This is going to work in Daniel Penny's favor, no?
Well, it's going to work on both the prosecution as well as the defense favor, because in the end, they have to apply those facts to the law. When you apply it to the law, it's not reasonable for Daniel Penny to have used deadly physical force. Also take into account that there's a duty to retreat in New York before you use deadly physical force. So here's going to be a big issue as to whether those 12 jurors, when they are selected, will be able to follow the law and actually apply the facts to the law as it's stated, without fear or emotion or sympathy to either side.
So, Bob, the biggest issue I see for the defense is how long Daniel Penny allegedly held on to Jordan Neely. 6 minutes, that's what's being reported, and arguably past the point of him struggling. The people who were in fear left the train cart. So how can you justify him holding on for so long?
Yeah, that's going to be the best. Like, if I were prosecuting this like I used to do as a homicide prosecutor, I'm going to go right to that point. I'm going to go to the point that at a certain point, it becomes what could be reasonable in the beginning becomes unreasonable. To Bernardo's point, at a certain point, it becomes unjustifiable use of force. What I think the defense is going to argue to counter that is to say that the threat was not neutralized, because when they're trained in the military where he was trained to do this, quote unquote, chokehold or submission compliance, they're not to let go until somebody from a higher authority comes and relieves them. So we're in one of these situations in which people are trained in combat, bringing it into the civilian world. But the defense is going to have a big job on their hands to justify that 6 minutes. I think they're going to be okay in the beginning of the encounter, but I think they're going to have a problem getting around the end of that encounter and for how long it took. And I should just have to say parenthetically, Jesse, he did put him in the recovery position after he stopped breathing. I'm not saying that was a great thing, but it shows that he wasn't really trying to do significant harm. He was only trying to neutralize him. And to Bernardo's point, the only issue is whether the jury feels it's reasonable. I think there's a lot of jury nullification at play here.
And look, the defense has suggested, and you mentioned it too in your opening, that might not have been what killed Jordan Neely, that it might have been complications from K2 with a synthetic drug that it was in his system. If the jury believes that and there's credible evidence, this whole trial changes dramatically. But great to have you both on. I could have made this an hour case, but you guys truncated it so well.
Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.